Good morning, everyone, and welcome to meeting number 3 of the Budget Review Subcommittee of Justice and Judiciary. All meeting materials received by the posted deadline were online earlier this week and made available for downloading. At this time, we'll have the secretary call the roll, and members, you know the routine. Please tell us your whereabouts when your name is called. Please call the roll.
Senator Schickel.
Present in my district.
Thank you, sir. Senator Webb. Senator Westerfield.
Here from Crofton. Good morning.
Thank you, sir. Representative Cantrell.
I'm here from my home in District 38.
Thank you. Representative Decker.
Present at home in District 58.
Thank you. Representative Elliott. Representative Hatton. Representative Nemes.
Here from District 33.
Thank you. Senator McDaniel. Representative Petrie. Representative Reed. Representative Massey.
Present from District 66 remotely.
Thank you. Co-Chair Carroll.
Present in the room.
Chair Fisher.
Present in the room. We do have a quorum, so at this time I will entertain a motion to approve the minutes of the July 7th, 2021 meeting. Do I have a motion?
So moved.
Seconded.
Motion is second to approve the minutes. All in favor? All opposed? Minutes are approved. So this morning we're going to hear from representatives first from the Administrative Office of the Courts to provide an update on court facility construction projects. Would the representatives from the AOC please come forward and introduce yourselves, and the floor is yours.
Good morning. My name is Jenny Lafferty. I'm the Director of Finance and Administration for the AOC.
Welcome. I'm Carol Henderson. I'm the Budget Director for the AOC.
Welcome. Please proceed.
So I'm going to first apologize because our presentation was intended to be presented by our Executive Officer of Court Facilities, Danny Rhodes, who's probably our subject matter expert, but he had a conflict and had to be out of the office this week. So you get us up instead, so I'm sorry.
Right.
But we'll do the best we can. And if you have any questions afterward, I know Danny would be happy to answer any questions that you have, or we'll be happy to get answers for you. That's his contact information right there.
All right. Thank you.
We did want to give you a short overview of the Department of Court Facilities and what it is that they do.
Could you please pull your microphone closer?
Absolutely. So we're going to start with a short overview of the Department of Court Facilities for AOC and what it is that they do. That department's comprised of 3 divisions: the Division of Capital Construction, which is really what we're here to talk about today, the Division of Real Property, and the Division of Court Security. The Division of Capital Construction is charged with overseeing the design, financing, and construction or the capital renovation of court facilities statewide. A court facility is defined as land and buildings owned or operated by a unit of government in which space for the Court of Justice is provided. So space for the courts is provided by counties unless otherwise ordered by the Supreme Court, in which case it could be held at any other location made available by the county and owned, leased, or controlled by the county. To compensate the county for the use of their local courthouse, the AOC pays use allowance and also operating costs to the county. So use allowance is typically the Court of Justice's share of the debt service in connection with the construction or the renovation of a court facility. When the facility is 100% KCOJ occupied, we pay 100% of the debt service. We also pay operating costs, which are expenses for utilities, janitorial services, rent, insurance, necessary maintenance, repair, and upkeep of the court facility. So counties are reimbursed for 100% of those costs if we're 100% in the building. We're charged with completing facility assessments on all the court facilities. The last facility assessments were completed in 2011. So we have just engaged an architect and engineering firm last year to come in and assess 37 court facilities statewide. It's based on the age, the space adequacy, projected needs, structural soundness, mechanical and electrical systems, security needs, and interior and exterior quality of the facilities. These are our current authorized capital construction projects. We have 11 ongoing right now in Henry and Nicholas, Bath and Oldham, Barron, Madison, Butler, Clinton, Crittenden, Jessamine, Scott County, and also in, well, we've got Madison listed, Madison. Our division of capital construction staff is pretty small. We have Danny Rhodes again as the executive officer. Some of you probably know Ronnie McCall. He was our long-term manager, but he has retired effective the end of July. So we're missing Ronnie. And then we have two project coordinators, Mark Bannister and Corky Moadano. So an update on our 2014 projects, Henry and Nicholas County. Henry County was authorized with an annual use allowance of $1.15 million and a size of 36,271 square feet. And it is currently 98% complete. Substantial completions anticipated later this month, and we have a scheduled move-in date of September 20th, 2021. And this shows the exterior, and I believe that is the circuit courtroom in the interior of the courthouse. And this project has actually been featured in a national publication for courthouses recently. It was a renovation and addition, and it's one that we're especially proud of. It shows a historical renovation of one of our old historic courthouses. The Nicholas County Judicial Center was authorized with an annual use allowance of $978,700 and a project size of approximately 30,000 square feet. That project is currently 83% complete. Substantial completion is anticipated later this year in October, and we're scheduled to move into the facility the second week of November. And this shows the exterior of the Nicholas County Judicial Center. Oldham and Bath counties were the projects that were authorized in 2018. The Bath County Judicial Center was authorized with an annual use allowance of $745,000 with a project size of approximately 20,000 square feet. That project is currently in Phase C, construction document development. They've identified a site on the 100 block of Water Street in downtown Owingsville, which is approximately a block away from the existing courthouse. All of the properties have been purchased except for one, which is currently in condemnation proceedings with, I think the hearing is scheduled for September. The county anticipates we'll be able to go to bid in late fall or early winter in 2021. And this shows the site plan on that block on Water Street. The courthouse will face toward the north, which is where Water Street is, and a rendering of the facility. The Oldham County project was authorized with an annual use allowance of $1.6 million, which was increased to $1.775 million last year at the county's request, with a project size of 50,000 square feet. And that project is also currently in Phase C construction document development. An early site and demolition package has been issued, and that package does include moving the historic exterior of the 1875 building, and the work for that pre-construction package is expected to begin this month. Bidding of Phase D construction will occur in early spring with an anticipated start of construction in late spring or early summer in 2022. And that is a rendering of that courthouse. In 2022, we had 6 projects authorized, Barron, Butler, Clinton, Crittenden, Jessamine, and Scott counties. Barron County was authorized with an annual use allowance of $3.1 million and a project size of approximately 56,000 square feet. The PDB has been formed. Professional service providers have been selected. Silling & Associates and Integrity Architecture is the architect for that project, and Alliance Corporation is the construction manager. Site options are currently being investigated. Phase A design will begin once the site is identified, with construction estimated to begin between 2022 or 2023. Butler County was authorized with an annual use allowance of $1.1 million and a project size of approximately 22,000 square feet. The PDB has been formed and an architect has been selected. Sherman Carter Barnhart is the architect for that project. Interviews for construction management services will be held on Monday. Site options are currently being investigated. Phase A design will begin once the site is identified, and construction is estimated to begin in late 2022. The Clinton County Judicial Center was authorized with an annual use allowance of $1.66 million and a project size of 30,000 square feet. Again, the Project Development Board has been formed with an architect and financial advisor selected for the project. Sherman Carter Barnhart is acting as the architect. Requests for proposals have been advertised for construction management services. Site options are currently being investigated, and Phase A design will begin once the site is identified, with construction estimated to begin in late 2022. The Crittenden County Judicial Center project was authorized with an annual use allowance of approximately $1.1 million and a project size of 20,000 square feet. The Project Development Board has been formed with an architect and financial advisor selected. Sherman Carter Barnhart is the architect on this project. The PDB has made an initial decision to hire a general contractor for construction services rather than soliciting for a construction manager. And it's anticipated that the existing site will be raised and a new freestanding facility built in its location. The Department of Court Facilities is currently investigating options for a temporary space in Marion, Kentucky, and has identified available property that's owned by the city. So this project is currently in Phase A design, with construction estimated to begin in 2022. And we do have a rendering to show of this project with a site plan. Jessamine County Judicial Center was authorized with an annual use allowance of approximately $2.7 million and a project size of approximately 50,000 square feet. The Project Development Board has been formed and an architect and financial advisor have been selected. The architect on this project is Brandstetter Carroll Architects. The Project Development Board has decided to hire a general contractor for construction services rather than soliciting for a construction manager, and has voted to explore alternate site options rather than renovating the existing facility, which was originally anticipated. Phase A design will begin once a site is identified, and construction is estimated to begin in 2022 or 2023. The Scott County Judicial Center was authorized with an annual use allowance of $3.6 million and approximately 65,000 square feet. The Project Development Board has been formed. Professional service providers have been selected. Brandstetter Carroll Architects is acting as the architect, and Trace Creek Construction is the project construction manager. A potential site has been identified. Negotiations are ongoing with the property owners. Phase A design will begin once the site is secured, and construction is estimated to begin in 2022. In 2021, the Madison County project was authorized as a capital construction project. It is a courthouse renovation for the circuit court building. The authorized project scope is $12.5 million at 35,000 square feet. This project had previously been authorized by the 2018 General Assembly as a lease project rather than a judicial branch capital construction project, and was reauthorized in 2021 as a judicial branch capital construction project. The project is already in Phase C construction document development, and AOC authorized contracts with the professional service providers are currently being negotiated, with construction estimated to begin in early 2022. Future requests. We talked a little bit earlier about facility assessments. We contracted GRW Architects in October to perform facility assessments on 37 counties. The assessment format and methodology is based on the age and history, the structural soundness, security requirements, potential environmental hazards, building code and ADA compliance, interior and exterior quality of existing court facilities, performance and life cycle assessment of mechanical and electrical systems, and space adequacy of the facility relative to the AOC program space requirements. For the development of the fiscal year 2022 to 2028 capital plan, we asked GRW to complete the first 12 counties that had been identified on the 2011 assessment ranking list. That is a list of those counties. It's in alphabetical order. The 2011 list is outdated, and so we just identified those first 12 counties that we believed had the greatest need based on that 2011 assessment ranking and asked them to assess those counties first. Owsley had been identified as one of the top priorities in the 2011 assessment ranking list. We do continue to believe it's a very needed project. However, because the county has declined participation in a project, it was replaced with Estill County for that initial 12 project assessment. The remaining 25 counties are listed here in alphabetical order. Assessments of these counties are anticipated to be concluded by May. It's Anderson, Ballard, Carroll, Davis, Edmondson, Elliott, Floyd, Graves, Hickman, Knox, LaRue, Letcher, Lincoln, Martin, McCracken, McCreary, McLean, Menifee, Ohio, Owsley, Powell, Rockcastle, Union, Webster, and Woodford. Based on the preliminary rankings of the first 12 assessments, these are the counties that were included in the capital plan for fiscal year 2022 to 2028. These are listed in order of need based on the assessments, with Leslie County having the greatest need. So it's currently anticipated that Leslie County is going to be included in the judicial branch budget request for fiscal biennium 2022 to 2024. After all of the remaining 25 counties are assessed, the final ranking of all the 37 counties will be adjusted and available to you. These are some pictures of the Leslie County Courthouse that shows its current condition. Some of the reasons that this courthouse was assessed as having the greatest need are structural deficiencies, poor quality mechanical, electrical, and plumbing features. The security is a concern, and the space adequacy is a concern. There's no grand jury space, no holding cells, and insufficient space for AOC programming statewide. So that concludes the presentation that we have prepared for you, and if you have questions, we're available to take those questions.
Yes, I have a few questions here. Now, are these facilities, are they financed with 20-year bonds or are any of those bonds being paid off that the bond capacity may, given your facility assessments here, may be available for future construction?
They are 20-year bonds. There's a few that are going to be paid off in the next biennium. The language in our current budget bill is for those that are rolling off, it'll go to offset the deferred funding, because for all these projects that Jenny was talking about, the funding is deferred until the 22-24 biennium. The debt service, the use allowance, the debt service, the operating costs, and the furniture and equipment costs. So those are all deferred, and we'll be asking, that will be in our baseline for when I submit the budget in November. Some debt will be rolling off, but not very much, because when the debt is paid off, we still have to pay the county 2% of the original capital construction costs, as defined in our budget bill. So there'll be a little bit of offset, but not a lot.
Okay, I was just doing a little quick math here. It looks like the new facilities or the renovated facilities are averaging between $450 a square foot to about $560 a square foot. How does that compare with other states? It seems pretty expensive to build a courthouse with that kind of square foot cost involved. How does that compare with other states?
It's pretty much exactly in line with other states, or maybe on the low side. I know Danny has been involved in a national group of state administrators, state facility administrators, and that's one of the questions that they've looked at this year is what is it costing per square foot to build a courthouse? And of course, costs are more this year than what you would anticipate because of materials being what they are. But everybody has seen an increase, I think, of about 30% this year. But it's running right in the line of $400 to $550. That's about what it is across the country.
Are these estimates that you've made for the current projects realistic given the inflation that's going on in the building industry right now?
What we're finding is as we bid these out, was it $400 per square foot what we estimated?
Yeah, when we estimated these to put them in our budget, it was estimated a little bit over $400 because we estimated $400 square foot. Then the capital plan instructions call for an inflationary factor depending on what biennium we're asking for. So like Leslie County, for example, was about $423 a square foot is what we budgeted for.
And what we're finding with these projects right now is across the board, material costs are significantly higher than what we anticipated, but the interest rates are significantly lower than what we budgeted for. And so it's coming out sort of right under the budget for the maximum authorized use allowance.
What rate is the state getting on its bonds right now?
We around 2%, like
that's pretty
2.1. You know, it varies obviously for when their bonds are sold. But
all right, now one more question about ownership of the courthouses. Is the ownership, what state agency owns these?
State agencies don't own the courthouses, so the county government will own the courthouse. The bonds are issued by a public properties corporation that's established by the county under KRS 58, which means that while the bonds are, while there's existing debt, that the title to the courthouse is held by that public properties corporation, and after the debt is paid, then the county owns the courthouse. The Court of Justice occupies it, and then we pay that use allowance as well as operating costs.
And you said in one case, Owsley County, I believe you said, did not want to participate in this. What do you mean by not participating?
Because for our projects, bonds have to be sold by the counties. If the county government is not willing to sell the bonds, then we're really foreclosed from moving forward with the project.
All right. Senator Westerfield. Senator Westerfield has a question.
Thank you, Chairman. Ladies, thank you for your presentation. I may have missed it, but I'm curious, and if I did, I apologize for making you repeat it. How many courthouses are left untouched so far from this couple decade initiative to replace or to renovate all these courthouses? How many are left that have not yet been touched? That's my first question.
We believe it's this 37 that we're having assessed currently.
And how many, and this is related to what you just mentioned in your response a moment ago, that the local governments retain ownership. I know that there are some counties where it's a problem because once you all build a new facility, you've got old courthouses that sit vacant that counties are having to foot the bill for, that they can't use or can't fill up with anything. Do you know how many counties are in that boat or are facing that sort of circumstance? How many old courthouse facilities are sitting empty?
That I don't know. You know, we do try to work with each county. If there's an existing facility that they would like us, to replace, like for example, in Crittenden County, where we're planning on raising the existing facility and building a new facility on that site, we'll try to do that. So we really do defer to the county a lot in those situations so that we help them with their existing facility. We don't want to leave a county holding a facility that they can't manage and move forward with.
Is the number of counties in that situation something you all could report back to us, or do I need to go to KCO and get that answer?
Senator, are you asking for if there are any existing courthouses sitting empty, or are you asking if we build new buildings, which counties would be left with buildings?
Well, now that you frame it that way, I guess both. But my first thought was the first answer, that how many are sitting empty. But I think also I'd want to know how many, once you build one, are in that situation.
Okay. We'll have to check on that. To my knowledge, there's none that are sitting empty, but I could be wrong. But we can get that back. That information.
Usually a county government will move its offices into the courthouse if we vacate it.
That's been the case here in my district, most recently being Todd County. And of course, Logan County. Logan County's government fiscal court meets in the old courthouse, and so does Todd County's. And so does Christian County, for that matter, though the judge executive's office is across the street. The last question, Mr. Chairman, if I may.
Please do.
Of the 36, do you know that you're still reviewing? What's the timeline for completion of that? When will we know about those 36, whether or not you should build or renovate or what have you? Is there a timeline plan for getting those 36 reviews done?
We have assessments completed of the first 12 that we had identified as being the most needed based on the 2011 assessments. So those are completed. The remaining 25 will be completed by the end of May.
Thank you, ladies. Thank you, Chairman.
Thank you, Senator. Co-Chair, Senator Danny Carroll.
Thank you, Mr. Chairman. In relation to these facilities, once they are complete, and if there are unexpected significant maintenance issues, HVAC, et cetera, are there funds that come out of your office to help cover those, or is that entirely at the county's expense?
No, we pay our proportional share. So if the Court of Justice is 100% in the building, then we would pay for 100% of that repair. The General Assembly was kind enough in the last budget to give us $3 million for a maintenance pool. And so we have those funds available to do those kind of renovations, whether it's a big ticket item like a roof or HVAC, or it's just simple of like painting something. So,
are there many counties that do have separate facilities? I know in Marshall, the county has a separate courthouse for the county administration, and then there's a judiciary center. So is that model becoming more widespread, or is it normally just all in one facility?
In most counties where we've completed a project, there are two separate facilities. There are very few counties where we have we call those mixed-use facilities, when the county government functions are also in the judicial facilities. There are very few counties that we've completed a project in that have those mixed-use facilities.
Okay, very good. Thank you. Thank you, Mr. Chairman.
Thank you, Senator. Representative Nemes has a question.
Thank you, Mr. Chairman. And thank you for the presentation, ladies. I have three distinct questions. Number one is, are there any places in courthouses, in the counties where we have new courthouses, and I'm talking about since 2000, I think 2001-ish is where we started the boom. Are there any counties where we rent space outside the courthouse? And if you don't know, that's fine. I just like a list of all those areas, obviously, and a reason for the rentals. Do you know if are there any?
I believe there are, but I don't know off the top of my head which counties. So I would have to check on that and get back to you.
Yes, so I would request a list of all counties where we have the new courthouses in the last 20 years or so, and what space we're renting outside the courthouse. And also, is anybody renting space in our courthouse, like Department of Public Advocacy, any newspapers or anything of that nature that are in the courthouse that are not Court of Justice related? The second question I have is, I know that in 2004, 2005 timeframe, the General Assembly approved, I think, 31 courthouses. Those will not be coming offline in the next biennium. So your comment about that you said there won't be a lot of money, a lot of debt being fully serviced, so we can't save a lot of money. I think that's definitely true over this biennium, but in the next couple bienniums, there will be a substantial amount, it seems to me, a substantial amount of that will be finished, if you will. And so I'd like a list of, when those are coming off and what kind of savings we can anticipate in those areas. Is that a clear request, or?
Yes, I have that. Yes, I have that information. Like in fiscal year 23, what's coming off I talked about the 2% that we have to give to the counties. So the savings over what the bond is and what the 2% to AOC is, 2% to the county, the savings is like $1 million. In fiscal year 27 is when it really starts. That's like 3.9. Fiscal year 28 is 7 million. Fiscal year 29 is almost 6 million. So there are going to be some fiscal years where a lot of debt is going to be rolling off. But in this upcoming biennium, not a lot. But I do have that list, and I'll be happy to provide it.
All right. Thanks. And then the final thing is, I think I heard that there's a county where the General Assembly approved a renovation, and the Project Development Board has decided not to renovate, but to look for space outside the courthouse square, the existing courthouse square. Did I hear that correctly?
I believe that one was not approved necessarily as a renovation, but it was approved just as a project. And we had originally anticipated that it was going to be a renovation, but they have determined that they don't want to renovate. The county doesn't want to renovate.
Okay, my question, the reason for my question is when we approve projects, ever since Chief Justice Lambert, and now Chief Justice Minton, the thought has, and with the General Assembly, the thought has been we want courthouses, unless there's a significant reason to do otherwise, we want our courthouse to be downtown, so our squares, our lose their vibrancy. And so the General Assembly has all approved either new projects or renovations. So I just want to make sure that that this one's not something the General Assembly needs to go back and approve a new project rather than just a renovation. I think that I'm not sure that if it's approved as a renovation, they have the authority to do that. I'm not sure they don't. I just don't know. But I was just highlighting that for you guys because it piqued my interest. Thank you, Mr. Chairman.
Yep, we'll go back and look at that. We'll go back and look at the language, and if it's not approved just as a project, if it's approved as a specific renovation, we'll be happy to let you know.
Thank you, ladies. One final question from Senator Johnny Turner.
Thank you, Mr. Chairman, and I appreciate you allowing me. Thank you, ladies. I have some questions. As one of the legislators that originally got this thing started back in the 2000 era, I thought there'd be some consistency in the buildings, but as a practicing attorney who's went in many of them, they're not. And I'm interested in trying to get something of consistency in the planning, designing, engineering. And I'm going to bring these issues up, if that's with your permission, Mr. Chairman, that I see. One instance, the windows wouldn't open. The courthouse was built with no windows, and the air conditioning went down. They had to shut the court down for 2 weeks. I think that the engineering staff in this should be required to put windows in those buildings for the protection of many reasons. And I think they had to come back in and redo that courthouse after they shut that down. I have a problem with space entrance. We have the public standing out in the weather because you can't get but 5 people in the door because security is at the door. These things are not user-friendly for the public or the people that have to go in there, lawyers and people that have to go in there every day. And I've been in many of them in many counties all over eastern Kentucky and Fayette County. I think I was involved in Fayette County. One of the things we required initially was that they fix lock boxes for people who were carrying concealed weapons so they could leave them there. You go to a courthouse now, I believe Laurel County is the one I went in, and they say you got to take it back out to your car. There's no sign, and I walked in the rain about half of a football field and had to walk back out to where my car was. These things are not consistent, and I think it ought to be mandated that they have boxes for concealed weapons at the entrance, like a bunch of the ones that in the 2000 were. There should be signs in the parking lot telling you things. Laurel County has a big parking lot that you will have to walk half of a football field to get to. That's just my not picking on Laurel County. Many of them don't have, the public stays there all day, and many of them. There's no water machines, there's no Coke machines, there's no nab machines, and it should be mandated that they be in each one of them. These are not Taj Mahals that the judicial system should treat the public any different than the old courthouses did, and I see it in many of them. and I go in and get treated the same way. You go in, lawyers have to go there, public have to go there. You go in a bathroom and you're carrying a file, and there's a sink that's made where you can't know where you have to lay it in the floor. There should be some consistency there. And I can go on with more, but I would like to get with whoever's in charge of this to have a meeting with people who actually work in those every day, so there can be some consistency in every judicial center that's built hereafter, so that we don't have to go back and remodel a number of them. The other thing that all the practitioners and the public have with them, the ceilings are too high. You can't hear. We go back to the Bell County Circuit Court that was built before the new judicial ones, and that was the problem. You had to yell, and this is true in the one I have in Harlan County. It's very hard for the judge to hear, us to hear, the jury, anybody. And there should be some research done before we just automatically build these ceilings 20 foot high in these new facilities. I just don't think there's enough concern of what they're going to be for the rest of the lifetime, because they're public owned, operated buildings that should be given public concern first. I hear it complained everywhere I go from the people in the courthouse, how they feel mistreated by the facts of just what I said, going through the security. I was mandated to pull a handkerchief out of my back pocket when I went through one of the securities from a young man. Okay? So it's got many inconsistencies in the buildings, and they need to be consistent as to serving the public. We're taking them away from the old courthouses, and I've been in all of them, been practicing 40-some years, and I'm no better than nobody else. But I have this problem, and I've been in, like I said, Pike. I can just keep going through all these counties. Letcher, all the way down to Whitley's. I've been to McCrory's. I've been to Leslie County is the most needful judicial that I've been in. I've been in Butler County. I mean, plenty of Jeffersons, Fayettes. So I've been on, not so much. I've been in Bowling Greens, tried a case with Judge Minton in Bowling Green. So I've been in many of them, and they're not consistent, but they need to be. And the windows, I mean, all these things should be considered by every architect. And I know it's the local group, at least that's the way it was back before. There was a number of people picked as a local group to decide how that courthouse is going to be built. And that's not proper unless they're all practicing attorneys, judges, and people that consider the needs of the people that's going to have to live and stay there every day and suffer from the way it's built. So I asked to be here today to put that picture out and get this. I didn't want to go straight to Judge Minton, but I will if need be.
I appreciate your comments.
And I'll meet with whoever needs to and get a group of people that work with a bunch of people who actually live and practice in that courthouse that you're going to do to get some consistency to take care of the public, because they're the ones that's paying for it. Whether it's a judicial paying or the county, it's always the taxpayers that send us up here that's paying for it. And that's who we're supposed to be protecting and building these buildings for.
No, I appreciate your comments, and they're actually very timely. We do have construction criteria development that's mandated, and it's an administrative procedure that's adopted by the Supreme Court, but it's currently under revision. So it's very timely that you're bringing up these comments right now, because some of these concerns I don't think are addressed in the construction criteria. So I would encourage you, I'm going to pass these concerns along to Danny, and I will give him your name and ask him to reach out to you, because I think some of these concerns are things that we can consider and include.
Well, I would probably request that he try to schedule a meeting with a bunch of the practicing attorneys and people that are living in these judicial centers to find out the problems and to make that. The windows are the biggest one I saw that didn't really consider in that design. It was built many years ago, but after that I threw a suggestion out to them to make sure they put windows that would open in all of them. But these other problems are just consistent throughout the systems in the state. So,
yeah, I appreciate it. Thank you.
Thank you, Mr. Chairman, and thank you.
Thank you, Senator, and thank you, ladies, for your presentation today. It's very helpful to us to understand the construction of these facilities. So our next, who's it? Oh, Senator Webb, please. Senator Webb.
Thank you. Yeah, I appreciate some of the thing. I wasn't going to say anything, but Representative Nemes and Senator Turner have brought up some things that I was having flashbacks. And I've been doing this a long time, and I was had the privilege, I guess, to help write a lot of these projects in when I was second ranking member of the Budget Committee in the House, and with an emphasis on the justice side. So, we have historically interacted with AOC and the courts, and not always been in agreement, but certainly have always come to a pretty good resolution. But my colleagues bring up some valid points, and the history is correct. And as a practitioner who's been in I practice all over the state, I appreciate the process now, and it was sort of an experiment, and I think it's well better refined, but not always accurate. So the last time I was in the Nicholasville courthouse, I had a broken leg, and they had to bring court to me in the clerk's office. So I can't wait to go to Nicholas County. But Greenup County Courthouse is just, I'd like to talk to somebody about it, look at some of the assessments and see where it may be on there. That's one that kind of comes to mind. And it's in my district. I practice there all the time. And we just got a new Supreme Court justice from that courthouse. So he's well aware of the need there. But I would like to, if I can provide any historical context or legislative intent along those lines, and some of the successes and failures along with Representative Nemes, because he was there in administrative capacity, I would be glad to do that too, because I certainly share the sentiments of my colleagues in this. And I just felt compelled, since we were talking about standards and consistencies or lack thereof, and accommodation to the public as well as officers of the court, I think these are legitimate concerns, and I'll be glad to, I'd like to partake in some of that communication. Thank you, Mr. Chairman.
Thank you, Senator. Do you have any final comment?
I would just add that Greenup County is in that list of the top 12 needs. So it is one that will be coming up in the next couple of years.
All right. Thank you. Thank you very much. Our next panel is providing an update on the Department of Public Advocacy. Damon Preston and Scott West are with us. Welcome, gentlemen. Please proceed.
Thank you, Mr. Chairman. Actually, before I start this, I really appreciate Senator Turner's comments on the design of courthouses. Of course, we have lawyers in all of those courthouses, and public defenders have unique needs with large volume of cases that they're taking, and they need to go to the bathroom, and they need snacks too. And I really appreciate that insight, and we would be interested in being involved in any process to update those requirements as well. I really appreciate the opportunity to talk about DPA's needs today. On June 14th, I emailed Chair Fisher and Chair Carroll to alert them to the crisis that DPA is facing in attorney resignations. That was on June 14th. Since June 14th, since I sent that email, DPA has had another 33 resignations, including 23 attorney resignations, and within that, 4 of them were trial office supervisor attorneys. Now, for some context, DPA only employs about 300, little over 300 attorneys, and we have 35 trial offices. So since the day that I alerted this committee to a crisis, we've lost another 8% of our attorney staff, and over 10% of our trial office leadership. So what has been a crisis is approaching a catastrophe. And at the end of this presentation, I'll talk a little bit about what the system could look like if this continues without a solution. But it is a significant problem. And now, obviously, when we're talking about public defense, we're talking about a constitutionally mandated service. Of all of the wonderful things that this legislature appropriates funds for, most of them, overwhelmingly most of them, probably 95% of them, are policy decisions. Should we spend money on this or should we spend money on this? When it comes to public defense, you don't have a choice of whether to do it. It has to be done. And if it's not done through an organized, efficient, professional system like DPA, it will be done. It'll be done in other ways that are way more expensive because it is a constitutionally mandated service to provide. Here, I've broken, for purposes of this presentation, I've broken down state government full-time staff attorneys into these three categories. There are about 704 that fall into this category, and DPA employs about 40% of them. Now, other executive branch agencies, those are the Energy Cabinet, Education Workforce Development, Cabinet for Health and Family Services, who hire lawyers for the purpose of advising employees on legal matters or representing that agency in legal litigation. Those agencies, as I would refer to them, are agencies with lawyers. And we are competing with them even though we're an agency of lawyers. And as I will explain, there's a big difference between having an agency of lawyers, over 300, 281 staff attorneys plus supervisors, over 300 lawyers. There's a big difference between that and an agency that hires 4 or 5, even a couple dozen attorneys. The other group that we compete with that are funded by state government are local prosecutor offices. Those are assistant county attorneys, assistant commonwealth attorneys, and the elected officials. For purposes of this graph, this does not include elected officials. So if you look at this and you're saying, now wait a minute, we got more defense attorneys than prosecutors, what are we doing here? Just know that this local prosecutor offices does not include the 177 elected officials that are prosecutors. It also does not include any part-time prosecutors. There are a number of part-time prosecutors that add to their resources. We do not have any part-time defenders. All defenders are full-time employees. So that's the breakdown here, roughly even, but DPA does have a few more. As I talk about the problem, I want to focus first on just an example, and there are many people that fall into this, but I've chosen one. PS was a real attorney for us. We hired him straight out of law school in November of 2018 while he was awaiting bar results. We hired him as a law clerk at our standard law clerk salary, which is $35,000. Shortly after he came on staff, he was sworn in. He fortunately passed the bar and was sworn in, and we hired him at the entry-level staff attorney 1 for our standard starting salary, $45,000, which I will note is way too low. A licensed professional that's holding people's liberty in their hands, we should be paying them more than $45,000. But that's the best we can do right now with our existing budget. PS worked as a staff attorney 1 for a little over a year. Then he met the criteria of a staff attorney 2, the second of 3 classifications in state government for staff attorneys. And we promoted him and gave him our standard beginning salary for a staff attorney 2, which is just slightly over $50,000. We intended it to be $50,000. Personnel rounded it up to $50,004 is how he arrived at that. And at that point, then in early 2021, PS had a choice to make. And here were his options. He could stay with DPA, and he would be eligible for a staff attorney 3 position. Under our policy, we've tried to make staff attorney 1, 2, and 3 a career path. And so to qualify for staff attorney 3 in DPA, you have to have the ability to handle the most serious cases, death penalty cases, complex sex cases, complex financial transactions, things with DNA, juvenile cases. You have to be able to handle every case. And that takes about 4 years of experience in our agency. So he could have hung around until late 2022 and gotten a promotion, big old promotion, and got a raise all the way to $54,000, which is what we pay our experienced attorneys. Once he had 10 years of experience, he would have got another bump, a big bump of $1,200 up to $55,000, and you can see the other steps there. And maybe if he stayed with us a full 20 years, he would have gotten $58,000. Now this, I'll stop at this point to say this all presumes no increments, which I would love not to presume. And I'll take it as an aside here. I'm aware of other conversations that have gone on and testimony at the Appropriations and Revenue Committee about the lack of increments and the crisis across state government. And we share that, and we've experienced that, and that has contributed to these issues. And we fully support and hope that this legislature comes up with, makes a commitment to annual pay increases, whether it be 5% or something else. Something annually would certainly help all of these issues. But our attorneys are facing specific issues, and that's what I'm focusing on today. And so PS could have stayed with us for that career path. Maybe he'd be promoted to supervisor, and we pay our supervisors $58,000 a year. But PS, once he had 2 years of experience, he qualifies under state government personnel for a staff attorney 3 position because only 2 years of experience is required. We try to stretch it out because we want people to stay with us. But it's almost like when you're driving and you're trying to be safe and you slow down to increase the space between you and the car in front of you. And every time you do that, what happens? Somebody cuts in front and they take up that space. Well, that's what's happening. We've tried to slow down our process so that people stay with us longer. But in this case, and in so many cases now, other state agencies are looking for an experienced lawyer. And in this case, PS applied for and received a position of $61,990, almost $62,000, a $12,000 raise to go to another state agency. We don't pay staff attorneys $62,000 at any phase of their career. And so he had to make a choice, and he did. And PS was one of those attorneys that I think if you asked him today, he'd say, I'd rather be doing public defense. Came to us committed. He handled, he was starting to get involved in death penalty cases. He wanted to do criminal defense. But given inflation, the cost of things, and his desire to start a family and all of that, he couldn't turn down a $12,000 raise. PS is on this list. He's third from the bottom, but this is a list just since 2019 of some of, this is not an exhaustive list. It doesn't have any that have happened in the last 6 weeks since I sent that email. These are people that have left us to go to other agencies in state government or to local prosecutors' offices, and you can see the red column on the right as to the substantial raise that the attorneys received. 2 of them on here, we don't know what they were making, but they went to legal aid. When I'm on the board of Apple Red, I fully support civil legal services, but for most of my career, public defenders haven't lost attorneys to civil legal services, but we are now because they can pay more than we can pay. A couple of pie graphs just to show kind of what some of the issues are. So of those 700 government paid staff attorneys, if you take the top 200 of those, DPA only has 3 among those top 200. Over half are prosecutors. These are salaries that range between, I think it's 70 and a little over 100,000. DPA only has 3 attorneys in that. I say this for a couple of reasons. Number one is we don't pay even our most experienced attorneys. Other agencies pay their experienced, quality, excellent attorneys at a much higher rate than DPA can. But the other message here is if you're in PS's situation, as we have so many attorneys, well over 100 attorneys with less than 3 years of experience that are going to think about their options. And if they know there is no chance I'm ever going to be paid at that level within DPA, then at the front end of their career is when they have a real question. Do I want to stay with this agency? Now, if you look at the other end of the spectrum, if you look at the 200 lowest paid, we've cornered the market on that. There are some low-paid prosecutors, and prosecutors are going to come and talk about that, and we don't believe prosecutors should be paid this low either. But among state agencies, if you take out the prosecutors, there are almost no low-paid attorneys that don't work for DPA. within the executive branch. This is not intended to be read for the substance. This is just a graph. Essentially, those top 200 salaries are that box at the top. The bottom 500 are the box below the break. Red or pink represents prosecutor offices. Yellow represents DPA, and white represents other executive branch agencies. You can see graphically here all of the low-paid attorneys that are with DPA and the significantly higher-paid attorneys in other offices. Now, when I've showed this graph, this picture to people, a good, legitimate question that comes back is, isn't this just because DPA hires people fresh out of law school? Isn't that why you've got all these people at the bottom of the scale? Because you hire inexperienced lawyers, and these other agencies hire experienced lawyers, so they would pay more. And there's certainly some truth to that. We do hire a lot of people fresh out of law school, but the reason we hire people fresh out of law school is because our experienced lawyers are leaving. It's a cycle. If we had a choice, we'd hire a lot fewer law school graduates and we'd keep our experienced attorneys, but that doesn't happen because they're leaving. But the other reality here is we have a lot of experienced lawyers. We have staff attorney 3s, which is the highest level of experience within the state personnel classification. They make an average of $58,000. When you compare them with other executive branch agencies, these are not prosecutors because prosecutors have a different classification. Staff attorney 3 is a personnel classification for executive branch agencies. When you compare to those, the average DPA staff attorney 3 has 42% more experience, almost 15 years of experience, but is making 10% less than in other agencies. If you put those two numbers together, other agencies are able to compensate for experience of attorneys at a rate that's 56% higher than DPA. As a specific example of an experienced attorney, if someone thinks, well, DPA doesn't have attorneys that deserve more money. Well, if you consider our fourth highest paid attorney, I said we had 3 in the top 200. They're all, I should note, all of their salaries were raised when they were in a leadership capacity, and then they took a demotion, and because they were good service, we didn't take back any money. So they got that higher salary only through going to leadership. If you go below those 3, the fourth highest paid attorney for DPA has 26 years of experience. She has won a case at the United States Supreme Court. It's a pretty small list of people, lawyers in Kentucky who have that accomplishment. She's won at the Kentucky Supreme Court multiple times. She handles the most complex litigation, and she has a stellar personnel record. And she is the 228th highest paid attorney in state government. If you go right below her, we've got a trial attorney, 32 years of experience, 22 years with DPA. She's tried cases in practically every county in southeastern Kentucky. My guess is she's crossed paths with Senator Turner before. She's won acquittals and favorable resolutions in the most complex cases for 3 decades. And she is the 229th highest paid attorney in state government. It's not that we don't pay attorneys because they don't deserve to be paid more. We can't afford it. And this goes back to what I said about comparing an agency with lawyers to an agency of lawyers. Because we have over 300 lawyers, if I give a lawyer a raise, it impacts the rest of our system. I can't pick and choose. In some regard, because they're merit state employees, sometimes I'm legally required to give other people raises. But even if I'm not legally required, I still have to run a system with human beings. And if I'm paying some attorneys more, if I give one attorney $15,000 more, they're going to leapfrog 150 attorneys. If I give our, as you saw in the example of PS, our salaries are so compacted. I haven't done the math on this. I should have, because I thought of this example last night and I could have looked it up. If I give any one of our staff attorneys that aren't in the top 50 a $4,000 raise, they will leapfrog 100 attorneys because they're all making about the same thing. And we have no incentives for longevity. Again, because there's no increments. They get no raise unless I give them a raise, and I can't afford to give them a raise. Let me talk about leadership. Everything I've said so far is limited to staff attorneys, but our leaders are the worst paid staff attorney leaders in state government. This chart shows that people with in in other agencies, supervisors, which under state personnel system are grade 18, are actually paid more than our grade 19 managers. DPA's leaders are paid far less than in other agencies. Here's the chart for leaders. And again, I said we cornered the market on staff attorneys. We've really cornered the market on low-paid attorney leaders, because the yellow lines on this chart are all DPA leaders. The white are other agency leaders. So how did this happen? Just really quickly, we're different. We're an agency of lawyers competing against an agency with lawyers. So if another agency wants an experienced lawyer, they know they can get one of ours, and they can do that. They can give a $5,000, $10,000, $12,000 raise, and it doesn't have any impact on their other lawyers, or maybe in fact impacts 3 or 4 people. If I tried to match it, it would impact 200 lawyers, and I don't have the budget for that. We're also a victim of our own success. As I hope you're aware, DPA has a nationally recognized education and training system. If you do 2 years with DPA, you're going to be among the best trained lawyers in the state. You're going to have litigation experience. You hopefully will have a jury trial experience. You're going to be trained in appellate work and trial work. You're going to know the motions to file, and you're going to be very marketable. And so that is leading to our turnover as well, is other agencies and prosecutor offices know what they're getting when they hire a DPA attorney. And as to prosecutors, they see our people in the courtroom. And, you know, if I was going against someone and the other side that I go against every day has a really good lawyer and I've got a vacancy, I'm going to try to hire that lawyer, and that's what happens. And so many of our good lawyers, a lot of our best lawyers, are hired away by people who see how good they are and hire them. And the final reason that this has happened, which is important to understand from a budget standpoint, is this is probably the longest I've ever talked about DPA's budget, and I haven't used the word caseload. Caseloads have contributed to this as well, because for the last 3 decades, we've had excessive and at times unconscionable caseloads, and every penny that I and my predecessors have got have gone into additional personnel. So there have been times that we had money that we could have made an agency decision, let's focus on salaries, but that would have come at the expense of 10, 20, 25, 30 attorney positions, which then raises our caseloads to an even higher level. We felt an ethical obligation at every opportunity to focus on caseloads. And I'll say that COVID is a 99.9% negative thing, but the very small thing is that our caseloads are down. We expect they're going to rebound perhaps even higher than they were before. But at this moment, DPA caseloads are down because of the shutdown in the court system and the alternate ways that cases are being resolved in some cases. So this is a moment in time where we can focus funds on improving our current staff and not adding additional staff. So here's our solution. The first is return to a defender-specific classification to designate our attorneys as unclassified employees, and of course funding, and that's the one that I'm here to talk mostly about. But I'll go through these two really quickly. Hopefully I can deal with these through executive branch processes, and maybe this won't even require legislative action, but I'll just let you know that it's what I have in mind. When I was hired in 1997, a long time ago, into DPA, I was hired at the position Assistant Public Advocate Principal. That was my title. I had that for about 2 years, and around 2000, state government consolidated all state staff attorneys into those titles, Staff Attorney 1, 2, and 3. There may have been a good reason to do it at the time, but we lost our individuality within DPA, and then immediately started competing with these other agencies that their conception of a staff attorney is very different. If I'm representing the Cabinet for Health and Family Services on a lawsuit, that's very different from representing an indigent defendant, much less 500 indigent defendants in district court somewhere. And so I want to return to that, to where there's a career path for public defenders. I'd also say, with no offense intended towards any other agency in state government, there is a significant benefit in DPA of having a career. There may be other attorney positions in state government where they're more interchangeable, or the advantages of a 10-year attorney are not that much better than the advantages of a 2-year attorney. But in DPA, every year makes you a better lawyer. And right now, at this moment, 59% of our trial staff attorneys have less than 5 years of experience. And if this continues to where people are continually leaving, there's going to be no one to handle the death penalty cases, which means those death penalty cases probably are either never going to go to trial or they'll go to trial and then be reversed. And the same for other kinds of complex litigation, because you have to have competent counsel to handle those cases. So this creates a sustained career path. DPA attorneys fall within the classified system. This is one of the ways that we're at a competitive disadvantage from local prosecutors, because they're not as part of the merit classified system. And so a local prosecutor office can offer one of our attorneys a $5,000 raise just out of the blue. There's no process. I'm sure they have an internal process, but there's no state mandated process for doing that. And I can't match them because my employees are merit employees, and there's all kinds of restrictions on what I can do. So I would ask, and I'd say not all of our attorneys think this is a great idea, because there are benefits to the merit system. But I would like DPA attorneys to be considered unclassified. That would also allow me to immediately fill vacancies. One of the problems I haven't even mentioned so far is that when someone leaves, like last week, got notice that one of our staff attorneys was resigning, that's going to be a vacancy for 60 to 90 days. By the time we run the register, we do mandatory interviews, we get that person on, they give notice. All of the mechanics of state government hiring take about 60 to 90 days. If they're an unclassified employee, that reduces that time frame considerably. I don't want to leave this topic without pointing out, we do have to have some minimal protections, because the area of public defense is not an area that you want to have someone that could be fired at will necessarily, because there are other considerations. You don't want a judge pressuring a local office to fire an attorney for something they did in court. There are remedies if an attorney is acting unethically or in some way violating their duties. There are certainly remedies within the Bar Association, and there could be for cause termination, but we would want some minimal protections. The final thing is the money. Could you give me a glass of water? Thank you. With the gravity of the problem that I've mentioned, thanks. With the gravity of the problem that I've mentioned so far, you can imagine that I'm talking about a huge price tag. The price tag is actually not that high, because I'm not looking to break the bank. I'm not looking to pay attorneys market rate. I ran the numbers last night. Our attorneys, we pay a lot of our conflict attorneys $500 per case. Okay, our attorneys average about 400 cases a year. That means they're doing, by our contract rates, about $200,000 worth of labor. We don't pay them $200,000. I'm not asking to pay them $200,000. Even this proposal pays them a reasonable rate that is comparable to the average. That's where the numbers came from. The average of other agencies. So for less than $6 million, you could solve this problem, and we could have a career path that would allow people to stay in public defense if they want to stay in public defense and not feel the need to go to other agencies just to feed their family. Let me finish with this. This is the cost of inaction. We're already doing the first part of this. A lot of words on this slide, but the unreliable delayed court system, we've already got people that are handling cases they shouldn't be handling, that they're not experienced enough to handle, but we've got to give them those cases. We already have that. Cases are already being reassigned. There are courts that want to have a trial next week, that there are people probably in court today somewhere in Kentucky that are saying, the attorney on this case resigned, we're going to have to continue that trial. Victims wanted the case over. Restitution they wanted restitution to be paid. The court wanted to clear out some of the backlog from COVID. And DPA is standing up saying we can't do it because that attorney no longer works for us. That's going on right now. We're wasting state resources. We are spending so much money on training and recruiting. Many of you know, we have an annual trial litigation program. It's one of the crown jewels of our education process for new lawyers. We typically do that every fall. We have to do 3 this year. Every one of those is a substantial expense. We have to do 3 because of the number of lawyers we've hired in the last year. And given what's happened since June 14th with another 23 walking out the door, we may have to schedule a 4th because we're just spinning our wheels. We're training people to work for somebody else, and that's a waste of state resources. And I just added, right before I sent this to Mr. Ireland, I added this last one because I don't like to think about it. I've had conversations with many of you that are here in the room and on the Zoom that I'm not an alarmist. I tend to try to look at things objectively and coldly, and I not get emotional. But there's a growing possibility that this system's just not going to work. That too many lawyers are going to walk out the door, and we simply can't do the job. In the Paducah office, we should have 9 or 10 attorneys in Paducah. We fell to 3 recently. I believe we've hired a 4th. I believe we have a 5th that may have started August 1st. So we're building back. But we had the caseload of that should be covered by 9 attorneys, and we only had 3 attorneys there. They have 6 counties. They have all 4 river counties. They have Livingston County, and they have McCracken County. 3 attorneys. What that has awoken me to is that could be 0 someday. We could have an office that has literally no one in it. And when that happens, where do we go? Well, the statute actually has the answer to that. The court starts picking out lawyers and says, Mr. Nemes, I need you to handle this robbery case. And you're entitled to be paid constitutionally. There's a case at Bradshaw v. Ball that says Mr. Nemes is entitled to be paid. But Mr. Nemes, under the statute and certainly under the court and his practice, is going to be paid a lot more than it costs DPA. And this is 160,000 cases that go through the doors of DPA every year. And if we're paying a contract rate or a private attorney rate, it's going to cost you a lot more than $5.6 million to bail out of that system. We have, I believe, the best public defender system in the country structurally. I think the structure, the next year, hopefully you'll all be invited to some celebration because next year is the 50th anniversary of the beginning of DPA. 1972, Governor Wendell Ford signed it into law, creating a statewide organized public defender system. I think we have the best structural system in the country. If that goes away, either temporarily or permanently, because we can't solve this problem, it's going to be a lot more expensive and, in my opinion, a lot less effective. No offense to Mr. Nemes, who would handle that robbery case just fine. But overall, that system is going to be a lot less effective than what we've got right now. So we need your help. That's my message today. And again, I don't tend to be alarmist, and I don't mean to be alarmist. But when I sent this email, I was concerned. And 33 resignations later, I am very concerned of where we're headed. So I'd be happy to answer any questions, Mr. Chairman. I appreciate it.
Thank you very much. Our prospective public defender, Representative Nemes, has a question.
I would say I might be able to handle it okay, but probably not nearly as well as most public defenders. One comment and then 2 questions, if I might. We have a lot of areas of crisis in state government in our poor state. The 2 areas that I think have the most critical need in the whole state government we've heard from this meeting and last meeting, and that is our state troopers and our public defenders. Public defenders do an excellent job. If you talk to judges around the state, prosecutors around the state, and myself being in courtrooms around the state, I see that firsthand. So I want to commend the work that you guys are doing in these very difficult circumstances that your attorneys are in. They're doing great work, and they're doing the Lord's work in defending people and defending their constitutional rights. It's easy to say, oh, they're defending criminals. Well, they're defending people who've been charged and making sure that the system works for all of us. When you defend a guilty person, you also strengthen the rights of the innocent. And so I want to thank you guys for what you're doing, for the effectiveness with which you do it.
Thank you.
I think a $5.5 million request is modest, and I think it should be accomplishable. I do want to point out that on your on your slide, you mentioned you had Louisville Metro in there for $405,000 and $405,300. I want to make sure all my colleagues understand that Louisville is the only one that's not in the system that's controlled by yourself. They have their own unique history and so forth that was not brought into the system in the 70s. Fayette County initially wasn't either. About 10 years ago, it was brought into the system, maybe 15 years ago. But I do want to note that office is subsidized by the city of Louisville. So it's not like we pay for it all. And so we see that number. It would be bigger if the taxpayers of Louisville didn't also subsidize.
That's exactly right. That number was calculated with the Louisville subsidy included.
Right. So when we see that number, it looks big because it's 20% of our population, but it is subsidized by my taxpayers in Jefferson County as well. Here's the question. When you talk about non-classified employees, going to non-classified employees, I'm very concerned about that. I understand your reasons for it, and I think there's strong reasons. I want to think about it some more. But I would be more comfortable if we would couple that with independence of the public advocate office. Like, for example, now you have that contract with the Justice Cabinet. It's a little weird. We have people who are representing criminal defendants in the same cabinet with law enforcement, with prosecutors, with our jailers. Of course, jailers are at the county level, but with jail funding, and with the Department of Corrections. So it's a little different. It's worked. It fits and starts perhaps, but it's worked. I would be more comfortable if we change this statute. We have a statute right now that allows the governor to appoint the Department of Public Advocate, the public advocate yourself. I believe that should be transitioned, as many states do, to allow the board. The board is approved. My understanding is it's confirmed by the Senate.
No, it's a straight governor's appointment, and then Chief Justice.
And the Chief Justice. Okay, so they have that protection in place there. Mm-hmm. But I would be more comfortable if the board would appoint the public advocate. I fear, although we've not had this problem with our governors in the past, Republican or Democrat, and I don't think we have a problem with the current governor here either, of too much interference. But I can see a situation quite easily where a governor would say, I don't like some particular case. Oh, and so they go after the public defender and they say, you're up for reappointment, buddy. I'm not going to reappoint you if you don't do this to this person. Maybe they're being too successful. I don't know. Interference in a way that's inappropriate. So if we're going to go to non-classified employees, we must give more independence to the public advocate. And I think allowing the board to appoint the chief public advocate, your position, is a way that would make me a little more comfortable in going that route. Do you have a comment on that?
A couple of comments. Number one, we appreciate our friends at the Justice Cabinet, but you've identified the tension that exists well. We are in addition to just kind of being odd that we're all at a meeting in which some people are trying to incarcerate people and some people are trying to free people. In addition to that oddness, there's also a real practical tension in that we sue DJJ, we sue the Department of Corrections. Our clients are raising issues against Kentucky State Police. So I believe it's worked well. I was, I think, trial division director when we were placed in the Judiciary Cabinet, the Justice Cabinet many years ago. And there was a conversation at the time, maybe you were at AOC at the time, there was a thought that maybe we would go to the judicial branch, which the public defender system is in some states. I'm certainly open to a conversation on a higher level of independence than we have now, because of those issues. And whether it's the commission making the appointment, I'm open to that as well. As you might know, I was just appointed for a second term, so I've got a new 4 years to figure this out. And so I'd definitely be interested in the conversation that would increase that independence, because you're absolutely right. We've been fortunate that governors have not turned DPA into a political position, but there's no guarantee that can't happen. We had an attorney in Western Kentucky that just raised the defense in a case that involves the current governor and his actions when he was attorney general, and we wondered, how's this going to be received when we're an executive branch agency basically calling out the governor, and it was fine, but if
you go to non-classified, who has the right to fire? Is it the cabinet secretary who might be named in a lawsuit by an employee that they could have the right to fire? I mean, who controls the hiring and firing of those employees? Those things we need to to think about. And I think I don't know what the answer is today, but if we go to non-classified, I know who it should be. It should be the public advocate and not other people. Thank you.
Right. I agree. That's that general idea would have to be fleshed out quite a bit. And I appreciate your concerns.
Thank you, Senator Carroll.
Thank you, Mr. Chairman, and thank you all for the information today. And I too I can't say I always did when I was sitting beside prosecutors throughout my career, but it is necessary, and we must ensure that to offer equal justice, that those scales are balanced for prosecutors and defenders. So I will be supporting efforts to help you all during the upcoming budget.
Thanks,
A couple questions. How many attorneys at the peak did you all have, and how many now? And I may have missed that, so if I did, I apologize.
Senator, I don't have our current vacancies. It's very fluid, as I've described. When I talk attorney positions, I talk about if we were fully staffed. And so we have about 320, that 280 staff attorney plus about 40 supervisors, so about 320 attorney positions. I'm not sure what our current vacancies are.
Okay. And the other question I had, when a defendant is declared indigent, and correct me if I'm wrong, there are times that the judge will still require that defendant to pay some fee. Where does that money go? Does that go directly to the public defender's office? How much does that bring in? Historically, how much is that brought in annually on average?
Good question, Senator. That money does go directly to us, does not pass go, unless the clerk's offices go. So it's paid to the clerk, and we get payments quarterly from that. It's about $1.5 million of our budget, which is about, that'd be about 2% of our budget. So it is not an insignificant amount, but it's also not a huge amount. And like all other court-related costs, that has really gone down in the last 2 years. It was going down even before COVID, and certainly as the bottom fell out last year.
Do you feel within the court system that are judges consistent in what they require those that they declare indigent to pay? Is there a lot of discretion that a judge has on that, or is it a set scale based on proven income?
So it'd be no, yes, no to your questions. No, judges are not.
You're going to have to say that again, because I don't remember what order.
So judges are not consistent. Yes, the judges have a lot of discretion, and no, there's not a set scale. So judges are very inconsistent with how they assess those fees. There are some judges that will set a $50 fee pretty much in every case in district court that we're in, and then we'll make significant efforts to collect that fee. There are other judges that take a more of an approach that if you're appointed a public defender, I'm probably not getting $50 out of you, so I'm not going to assess that fee. And so the amount that we get from counties, and I haven't looked at it in a couple of years, but we used to compile yearly county by county lists, and there would be McCracken was always near the top of collecting public defender fees because the local district court bench particularly thought that was important, and we appreciated that support. There are others, and I'll just point out Jefferson County does not, and those fees in Jefferson County would go to the Jefferson County Public Defender Office by our agreement, but their philosophy is very different there. They do not collect near as much.
So is there a way through legislation, and I'm not making any statement of intent in any way. I understand that when people are declared indigent, there's a reason they're declared indigent. But is there a way through legislation to standardize that system more, to perhaps generate additional revenues to help cover the $6 million, and it would actually be paid by the people who are utilizing the services, and not in any effort to be unfair to anyone, but simply to standardize it and make it some type of scale which is fair based on the income that the people have?
That was tried in the 90s when you were a police officer. You may remember that there was a public defender fee of $50 statutorily. It was set at $50. The reason that was backed away was a couple of things. A lot of uncollectible fees, and so there was a lot of effort in the court system that went into getting someone to pay that, and you spend a lot more than $50 trying to collect that $50. And within the court system, we weren't paying for that, so they were spending their money to collect their resources to collect our money, which wasn't a great dynamic. And so that was attempted. So that model's out there, but I would say it was unsuccessful. I think but if there were some consistency brought to it, I think that would benefit the system, because our clients, if a client in one county should pay roughly the same as a client in another county for the same service. And so I'm open to suggestions on how it could be more consistent. We're always concerned if someone is assessed a fee that they can't pay and then they have to take a day off work to come to court and explain why they can't pay it. That's not a great situation. But we do represent clients. The standard for appointment of counsel is essentially, can you afford to hire a private lawyer? Well, there are a lot of people that can't afford to hire a private lawyer, but they do have a little bit of money. And we've never objected to those people paying a reasonable fee. The question is just, how do you tell the difference on who falls in that category?
So how much proof is actually required of income in the court? I don't know that I recall ever seeing any documents. It's normally the judge just asking, and then they declare them indigent.
There's an affidavit of indigency that's laid out. I think the form is actually in the statute, and if it's not, it was at one time, and now it's a AOC form. It asks for income and bank accounts and assets and child support obligations. It asks for both assets and liabilities. It's a pretty complex form. Now, I don't want to imply that people spend the amount of time on that they spend on their taxes. The form's filled out pretty quickly, but there are blanks for all the relevant categories, and a judge is required to consider those. And again, judges vary as to how much time they spend on that.
Okay. And then, Mr. Chairman, if I might, one final question. In looking at what other states do, have you all found any creative methods that have been utilized by other states to sustain the public defender's office through unique fees or programs, or are there any other avenues that you all have thought of?
There's no system that's substantially in any way funded by service fees, just because of the clientele. You're not going to get a lot of money from the people that we serve. The systems that avoid this type of discussion are the systems that actually have either a statutory or regulatory requirement for parity between prosecutors and defenders. Because those systems, then the prosecutor and defender are joined, and they're coming together to the court system to say, we need more money. I'm very uncomfortable putting up slides and saying prosecutors are making too much, because that is not my message in any possible way. But when I look at it and we're losing people to prosecutors, I have to point that out, that is a competitive imbalance. I would much rather be here with Chris Coron next to me saying the criminal justice system needs more money than me making my case and him making his case. So that's the only thing I would say. There are other systems that are designed that way.
So it's basically just all into one big pool, and everybody's treated the same to
No, we have our individual budgets under that system, but there is a formula to calculate. It wouldn't be a dollar for dollar, because prosecutors handle more cases than we handle. They have responsibilities we don't have. But there would be a formula of some sort that if they got $1, we'd get 78 cents or something like that.
Okay. Good information. Thank you, Mr. Chairman.
Thank you, Senator. Senator Webb will have the last question.
Well, just a couple follow-up comments and maybe a question at the end. But as to the cost-benefit analysis that Senator Carroll spoke of with that particular system in the 90s, that's correct. It did not fly from a cost-benefit standpoint, from administrative cost to collectability. And certainly the judges know best. In my jurisdictions, where I practice the most, the judges know best on who to assess, who not to. And I mean, that's why there's a great latitude of discretion there, because most of your judges know these things and have a pretty good feel for it. Maybe some ideological issues may come in from time to time in jurisdictions, but that's certainly correct. And I don't necessarily want to see us go back there, and I don't think clerks do either. But Secondly, as to the autonomy of the organization, once again, Representative Nemes and I are on the same page, and I have been on this page for many a year, that I always felt like this agency fared better in public protection or something similar with a basis of autonomy. Just, as lawyers, we have an appearance of impropriety and conflict of interest and all those things. It just kind of grates on me, I guess, my attorney side, with the structure and the placement and the litigation dynamics. And I've had this discussion with you and your predecessor for years on how are we inhibited by pursuing certain things because of the budget or the issue or the parties involved. And I think that's a very real concern, being a practitioner and being a former contract public defender, which I don't necessarily want to go back to that system either, even though as I think a viable private bar is necessary. And I have that discussion with you as well, because there's got to be a balance to be struck to maintain your viable defense bar, which I'm a proud member of. But, the contract system, it was embarrassing for me as a contract lawyer that had about 3 or 4 counties in southeast Kentucky to go to court with full-time employees and me making more sometimes under the contract than those dedicated great lawyers that they were. And we've got some of the best lawyers in America in this agency that do it every day, as stressed and as it is, especially right now. Some of the best. I don't see how we keep them. If it wasn't for the love of what they do and the people that they care about and serve, we can't keep them. And we're lucky to have the ones we have left, and we need to try to maintain that and bring up career employees like we used to have so many of to fill this out and to serve justice and the tenets of the Constitution. We're not only mandated to do this, but the Constitution requires all these things. And I appreciate the comments about that, because every year when I run, every election cycle, there's an ad. Oh, Robin Webb is a defense attorney. She defends criminals. I'm a constitutional lawyer. I'm proud to do it. I've never backed away from that. I'm not changing my practice. But, we can't lose sight of that. This is what we're here for. And it is public protection on many levels. And, justice is justice. No matter what side you're on, it's our job to pursue it along with the prosecution and law enforcement. We're partners in this justice game. And everybody just wants a fair shake and play by the rules and competent counsel. And that makes, we have to have that. And I get on my soapbox, but I'm very passionate about this. And I sit here today and look at those numbers. And my son just graduated from law school. He worked a little bit with the DPA. I'd be proud as heck if he chose that career path. But I look at these numbers and how's he going to pay his bills? So that is it's a real concern, and we're out there in it every day, seeing it. And if you don't think this pandemic impact on the criminal justice system is real, go to court with us one day. Let's have a field trip, because it is, and it's going to get better before it gets worse. So I appreciate what you do, and I'm like Jason. We need to talk about the structure, the hiring, the classification. That's an issue that might require some pretty intense meetings. So, thank you, Mr. Chairman.
Senator Carroll has one last question.
Quickly, Mr. Chairman, under the $6 million request, what would your attorneys be making?
That calculation, and I'll send you specific numbers, and I'll send it to Mr. Ireland so he can distribute it. It will maintain our starting salary. That does not include any raise of that. My hope is we can raise that at some point, but that's not part of this. And it sets up a levels based on experience. So I think it goes up to 55 for a few years of experience. And then the average, which was in one of the slides, of around 65, I believe an experienced staff attorney with 10 years of experience would go to 65. Leaders would go to 70, I think, 75, which were about the averages of other agencies. That's approximately, I don't have it in front of me, but that's what it is. I think the highest salary that I've calculated as part of that would be an experienced, maybe a 10-year staff attorney manager, which are the levels right below us, may make $80,000.
And you're comfortable that would allow you to maintain your staff throughout the state?
that would it's going to be a building process, because right now I have so many people with 1 year experience, and so to get to those levels, that creates a graduated career path. So yes, but to be fair, that is part of the reason that the cost is low, is because it creates these higher salaries for experienced people, and the people we've got are a few years away from experiencing those salaries. And so it creates an incentive to stay.
And so their salaries, that's it. There are never any bonuses or any other overtime or anything like that.
Our overtime is rolled into sick time by budgetary provision, and so that can't be that has no monetary value to our employees. And there are no bonuses, there are no time and a half, nothing like that. There are in executive branch, there are what's called ACE awards and AIR awards that are performance based, that I can give a limited number each year. And so I've utilized some of those for some of our very high performing people, but that's limited in both amount. And once you get one, you can't get another one. So
has there been any COVID funding related to justice that you all been able to take advantage of?
The only COVID funds we have, we got some funds for like masks and things like that. The only kind of structural money we got, we have a project going on in Hardin County that allows us to put some technology in the jail to communicate with our clients. And it's actually a pretty exciting project that at some point I'll communicate further about. But that allows us to see our clients in a safe way and allows them to sign electronic documents and things using some technology we've been able to buy with CARES Act funding. But that's it.
Okay, very good. Thank you, Mr. Chairman.
Thank you, gentlemen, for pleading your case. I think you have a pretty sympathetic jury here on your request, so we'll consider it in January. So
all right.
Thank you, gentlemen.
Thank you very much.
Any other questions? Otherwise, I'll entertain a motion to adjourn. We are adjourned.